Hello everyone. Um, we have a bit of a technical issues to start our initial streaming. Let's wait a few seconds to share the new link of the new stream with all the people, and then we can start. I hope that at any point you will be able to
Hello everyone.
restart the streaming from the beginning whenever that's needed. If you miss few seconds of this streaming. So welcome to our first of a series of streaming sessions and Ask Me Anything sessions that we planned to create here at Chino to answer to all your questions. We are receiving on daily basis questions on hot topics on legal and tech and digital health, and we wanted to provide room for everyone to listen at those lessons learned and some tips that we can share with you. Today we're going to talk about one of the most important topics nowadays, which is the usage of US cloud providers and tech providers, like for example ChatGPT in digital health. What are the challenges and how to solve them? First, who we are. Well, we are Chino-io, a company that since 2015 helps digital health companies to solve legal and technical challenges related to data. We combine legal and technical expertise and tech solutions to help companies solve all challenges on GDPR, HIPAA, digital therapeutics reimbursement process, apply to work in UK and France, US, and all countries. We have customers all across the globe. We are quite global European company, fully bootstrapped and fully remote. And we started by creating tech solutions, first certified tech storage solutions for digital health back in 2014 and 15. That's where we gained the knowledge and we are happy to share with you. Today, the agenda is to give a 15-20 minutes presentation, introduction to the topic, because we need to share some lessons here, and then leave the remaining 20-25 minutes for Q&A. So we will share, I will explain you, first of all, who has the problems with US cloud providers, why there are such problems, what are the risks, and how to use them correctly, so to give you concrete solutions. By the way, in the Q&A, just a second, sorry. In Q&A, we already received some questions from you over our Google form and that we sent you for the sign up. So we are going to share them, but in the meantime, you can also write in the chat here in the stream and ask us anything in the meantime. I will answer later on. So who has the problems with US cloud providers? Well, digital health companies, especially B2B companies who are applying to reimbursement schemes like DVG, DIGA in Germany, or the DTAC in UK, or the PECAN, the new reimbursement process for France, they have big problems with this. And companies that need approvals from the DPOs and hospitals and enterprises. So they we have expertise with companies dealing with hospitals like Charité in Berlin, Porsche, or Henkel, or many other companies with whom they are trying to establish a commercial relationship. They are struggling with dealing with the DPOs. And this applies mostly to startups, because startups are new to this space. They need to demonstrate trust, and they have the most challenges. But why those challenges? Why those companies are struggling? Well, authorities like BfArM, the entity that approves digital therapeutics in Germany, hospitals, enterprises, they are responsible of validating you as a company, as a provider. And they are very exposed to fines and reputation damage in case something happens. So startups especially are a big liability for them. And what is the problem? Currently there is unclarity on data transfers rules between Europe and US. But it's not really unclarity on rules. It's more accurately, it's an unclarity of the enforcement of those rules, how they are enforced currently in Europe. To give you more context, what are currently the rules? The rules are that in Europe, the data flow is free. there are no localization rules, especially for digital health, for normal services, let's say. There are no restrictions to that. And many other countries have established adequacy decisions, data transfer agreements between Europe and them, considering them equally okay for data transfers, like Canada, Argentina, UK, Switzerland, and other countries in Asia, etc. But what is the problem then? Well, the cloud providers are in US, and as you can see, US is not colored blue here. So US doesn't have a data transfer agreement since 2020, since the 20, when the Privacy Shield was invalidated by European Court of Justice, the Schrems II case. But we know that US cloud providers try to find mitigation strategies to that. So they establish legal entities and a lot of data data storage or nodes, computation nodes in Europe. So you can choose to sign the contract with AWS Luxembourg and choose to have the data in Frankfurt or in Poland or UK, etc. So they have found ways to mitigate that. But there is still a problem. There is still a problem because those US entities have subprocessors, and subprocessors, they have subprocessors in US. Their mother company is a subprocessor of them. So they provide potential access to US entities to this data. They don't transfer necessarily all data, but they provide potential access. So this fact that they have subprocessors in their agreements creates a problem. But why those subprocessors matter really that much? Well, they are the key thing here. They are the key thing to understand in any B2B relation scenario, sales that you have with your customers. You are typically a processor to your customer. You as a company, digital health company, whether you are a startup or large company, typically you sell in B2B space, you sell to somebody else, a hospital or a corporate, who are either controller or processor or something more complicated. There can be a mix of these articulations, but let's keep it simple. You are processor to them. You, as we described above, you are a liability to those customers. Your relationship with them must be defined clearly with a data processing agreement, DPA, or data processing addendum, but basically it's a contract which includes the list of data that is transferred between them and you and from you to them. So all data is mapped there. List of security measures that you will apply to this data, and the list of your sub-processors. So who is behind you? Well, who is behind you? It's your cloud provider. Your cloud provider that hosts your backend, your database. You will have a data processing agreement with those providers, and they will you will following the same process above. You need to expect from your providers to have very good data processing agreements to clarify all the security measures. For cloud providers, this is not a big deal. They are super secure and they're super good, but there is a problem. They have subprocessor who can make you non-compliant. They can have, again, US cloud providers have subprocessors, their mother company, but they can have other subprocessors for data backups, processing, AI, monitoring, assistance, other services. It's quite long list of subprocessors they have. So you need to check all of them, because any of them can make you non-compliant or can make you violate the agreement that you have with your customer. And that's what something that you don't want to have, right? So that's the problem with the chain of responsibility of those processors. But everyone is using US cloud providers, right? That's the fact. So far, what's the problem? I mean, so far there were no really fines, or at least we didn't see any, for companies using US cloud providers. This additional step further in the data processing flow. Only bans from DPOs or approval processes. Approval processes like the DTAC or the VG, the DVG in Germany. But, however, Google Analytics has been banned basically by all data protection authorities in Europe. Google Analytics is a B2B solution that transfers data directly, so there is no, it's one step less in the data transfer. Google Analytics is provided by US entity, so the data transfer is immediate from you to US. That was forbidden, and some companies were symbolically fined, like 50 euro fine. So just to avoid to create some marketing buzz. And recently we had one of the major cases, Facebook, that has been fined 1.3 billion euros for that data transfers to US. And Facebook is a B2C company that directly transfers the data at a large scale. This is huge. This has been huge, very recent. So we are seeing signs. It takes time, 3 years after the ban, to get those fines. So are the cloud providers, the case of cloud providers, the next one? We don't know that. We know that there is currently in process the definition of this new privacy shield, new data transfer agreement. But we know that the European Parliament is not happy with the current proposals. We know that there is rumors that associations will fight it. So there is really a lot of unclarity about this. We see worrying signs and not really great improvement in this situation. But then the question is, can you still use US cloud providers correctly, ensuring compliance, ensuring that everything is in place? And the answer is, luckily, yes, you can. You can. So that's a good thing, we believe, because it helps companies to use those great services that are provided in a correct way. But what are the steps? Well, a European Data Protection Board and European authorities basically created guidelines for companies. They are a bit complicated, so we try to simplify here them for you to make a list for you that is easy to digest and a process that we can clarify and help you with. First thing they suggest in this process is to map all data transfers. In your record of processing activity, map your processors, map your data transfer flows, map who are all your subprocessors, and identify which ones are creating problems. Then you need to conduct a transfer impact assessment, which is a document that specifies step by step what you need to verify, how to do that, etc., etc., etc. But basically, the two key things are implement technical and organizational measures. And I'm going to give you some more example here. But after you implemented the measures, you need to document everything, and basically document everything in the transfer impact assessment, in your data processing agreement, and also in your risk assessment, the company documentation that summarizes your risks and your mitigation strategies. So this is something that you need to document. But as I said, let's dig a bit into the technical measures, because those are the key things at the end to solve this problem. Technical measures, because you cannot solve anything that much with policies and documents. You need to actively modify your technical setup and implement something to solve these data transfers. Well, the most common technical measures that also European bodies suggest is encryption, in transit and at rest, pseudonymization, split or multi-party processing. What are those? Well, encryption, just encrypting in transit data transfers is not okay. This is obviously not sufficient. Is HTTPS, TLS encryption not sufficient. Standard encryption at rest, like the one enabled by your database, your cloud provider, when you click a box and it encrypts your database, well, that's not okay too. That's not sufficient. Some sort of record level encryption and key protection is a good direction. So you need to do something more to do that. And in that line, there is a technology, an approach called customer managed encryption keys, CMAC or CMK, which is really trending, which is a way that a method that cloud providers offer to take the encryption keys and store them somewhere else. They provide those solutions, but there are also European third-party providers, some large companies also providing this, which are interoperable with the cloud provider solution. So basically they plug in your cloud and they take the keys and they store the keys for you. as I said, if this is applied to the keys of your database, just the encryption address that your cloud provides by default, I think this is still not a sufficient method. You will need to encrypt your records at record level and have those keys somewhere stored to be able to claim that this data is really encrypted, that the cloud provider doesn't have access to this data, because otherwise, if the cloud provider manages your database, these keys stored somewhere else doesn't really improve that much the situation. So this is an unclarity here in the process, but there are guidelines. For example, BfArM published the guidelines for DVG, for the DGAS, for the digital health, digital therapeutics applications, and they go really into details about these things. And I really encourage you to read that if you want to have an opinion about it. They recently clarified the guidelines about this. Then there are other encryption approaches, such as end-to-end encryption. This is the best that you could implement, because the encryption keys will be on the client side or somewhere else, not in the cloud. The data will be encrypted before stored. That's great. That's the solution if you can implement it, but we know that this is okay for chats, for video communications, but not okay for health data. If you want to implement search operations or data analysis or AI on the cloud, you need the data to be unencrypted. So this is the encryption topic. Pseudonymization topic. Pseudonymization is a way of splitting personal identifiers from health data and putting a random identifier to connect those two pieces of information. And then you store personal identifiers on another provider, basically. In this way, you have really pseudonymization, and personal identifiers are not stored on the US provider. In most of the cases, that will be sufficient, because you can claim that the cloud provider doesn't have access to full data, doesn't have access to full data set, and cannot identify to whom this data belongs. This is okay, except in some cases, like for example for the DIGA DVG in Germany, where the law says that also health data shouldn't be stored on the provider. So there is a bit of unclarity there, because health data is the one that you would like to store for maybe for machine learning, AI, and so on. But for this digital therapeutics process, this is not okay. So there is a bit of discussion: what is your target market, where you want to go, and what is the best solution for you. You can find more information about these technologies, like pseudonymization, how to do it, and so on our website. We have been discussing about this since 2018, about this topic, because this is really the best also security risk management strategy in general, also in encryption, of course, but pseudonymization is the one that is probably easiest to implement. So you can reach out to us if you have questions about how to do this and how to document this in a correct way. And then the last technical measure that European bodies mention is split or multi-party processing, which is basically doing pseudonymization, because you split the data and you are able to split it in multi-party processing, which means that, for example, you store identity management on one side, pseudonymized data on another side. If you need to use AI, machine learning, you just share this data with third party to get this, the results of this AI. So this is multi-party processing, basically. There are many also more complex solutions there, but this is for a normal company, this will be the case. And it's great if you can do it. This is also connected to the ChatGPT topic I will mention in a couple of slides in a few minutes. Well, not in a few minutes, right away. So what about then, we discussed about these tech solutions and how that you need to implement and that you need to document. Okay, but this is all related to the cloud providers and storing the data of your app, identity and health data. But what about other tech solutions and services? There are other services that have similar challenges of data transfers. ChatGPT, push notification services. For example, we don't have alternative to push notification service. We need to use Android or iOS, Firebase, push notification. So we don't have alternatives here. We need to use a US provider which will transfer the data. Then we have the problem with logging, monitoring solutions. We have problem with OAuth, identity management solutions, with analytics providers, and every solution that entails some data transfers. So what is the problem with those? Well, the problem is the same as we described above, that you have your customer, your company signing a DPA, and then you need to sign a DPA also with your providers, all providers, and you need to check their data processing agreements. There was a lot of buzzwords and a lot of discussion whether US cloud providers, whether ChatGPT is okay to be used in healthcare, in digital health. Well, it's okay to be used as a B2C solution, no problem in that. You accept terms, conditions, and privacy policy, but in B2B, you need to check whether their data processing agreement is compliant with your customer agreements that you have above. It's a chain, remember. So there is no magic solution here. Check all of them, check the data processing agreement. If you need any help, feel free to reach out to us. Happy to see whether one of those agreements it's okay or not, what data transfers are happening out there. So Q&A time now. So we have few questions, as I said. Just a sec. Yeah, we have a few questions that we received already, as I said, via our survey that we sent to you during subscription. So our team is going to share them. If you have other questions, feel free to write them here in the chat, and I will be happy to reply to them. So the first question that we got is that, should I care about US cloud providers even though my product is not yet on the market? That's a typical question that also we get with other customer startups in early phases. And I think the answer is yes, you should care right away, because you are planning your design, your application, and you are spending time on assessing those providers, learning about them, and so on. So you are tightening yourself to a technology in a way of using it that will be hard to change later on. And then we saw also that the roadmap of companies is quite short, even though it takes time to certify your product, maybe. But the first moment you release an MVP, you try it with the users, and the moment you start a pilot, a trial with hospitals, you will see that that the data transfers problems are going to pop up, because in a clinical trial and clinical setting, you will need to sign a data processing agreement, you will need to have a data protection impact assessment, so you will face those big challenges anyway. How long, the second question we got is how long it usually takes to implement all the proper measures. What is your opinion on the easiest way? As I briefly showed in the presentation, I believe if you are starting a project in early phases, I believe the easiest way to implement those measures is the pseudonymization and avoiding storing personal identifiers, patient identifiers on US providers to transfer those. Because, or even better, if you can find complete European alternative in the meantime, because currently there is really a problem. But if you want really to use, if you need to use really some AI solutions, some specific providers, at least to implement pseudonymization. What I see difficult for startups, for example, is to implement encryption, customer managed encryption keys. And these complex technologies, I saw them applied in larger companies, in existing projects that are already running, and it's basically the easiest way to patch an existing system that runs on a cloud provider. So I would not encourage that for a startup, basically. Okay, so the third one that we got is, can I use the AI service offered by some cloud providers? As I briefly also mentioned already, yes, those are US cloud providers are offering AI services, machine learning services, data management, and so on. But also there are specific AI now companies since the beginning of the year. We have seen that. So you can use them. The important thing is that you don't transfer, for example, patient identifiers. But that's the main check to make sure that you are not really directly violating laws here, because that typically is really direct transfer to also to US, because for example ChatGPT and also the AI solutions, they typically don't offer the localization in Europe and the European entity and so on. So you need to really to consider that it will be a big violation. But once you make sure you split the data, once you make sure that you satisfy the basic requirements, then you need to verify anyway there are data processing agreements and that you are doing the right thing anyway, because in the data processing agreement they can say they can just don't have enough security measures for health data. Pseudonymized, almost anonymized, right? But not anonymized, so still personal data, and they may have not sufficient guarantees there. So you really need to avoid the transfer anyway, whatever data it is, right? So this is a thought process that you need to do. Always verify the data processing agreements of your customers or of your providers, your solutions that you are using. Okay, next question. I use US providers, but they do not store data. Are they still okay? So this happens frequently. For example, push notification services. Push notification is an example where you use them to transfer some small messages. You don't really use them to store the data, or there is maybe a temporary storage, but typically it's not a storage solution, so the data is deleted after a while. Can you still use them? Yes, you can use them, and in fact, for example, also in the digital therapeutics area with the DGAS, with the digital therapeutics applications, it has been clarified that you can use them, but you shouldn't transfer full sensitive data there. You should minimize the transfer as possible, and in this case, for example, in push notification, you transfer an ID of a user or of a record or of an app and a message notifying the other entity, the other end of the communication, that there is a new message, that there is new data, that this data can be retrieved by the application on the other side. So you really need to minimize the transfer here and never ever transfer full data. According to brief legal note, according to the European legislation, data processing means any potential access to the data or transfer of the data or manipulation of data. Doesn't mean any necessary storage. Any kind of processing is subject to these data transfer rules and laws. Okay, so the next question is, we have two more. If you have any additional question, feel free to share. By the way, if you want to reach out later to us and share other questions, you can find us on the website, or you can write to jovan@chino.io. So the next question is, the technical measures, encryption, pseudonymization, and split, are all required, or we just have to choose one? Can I do pseudonymization and encryption at rest only? Yes, so you need to combine them. You don't need to apply necessarily all. One could be sufficient if applied correctly. So if you use, for example, pseudonymization and you use encryption at rest, that's typically okay. Remember, pseudonymization means splitting personal identifiers from health data and storing them separately. If you are able to claim that within your health data there are no personal identifiers, then this data is already, secured somehow. Risks are reduced of risk of identification in case somebody accesses the data. So you have less constraints, less requirements when it comes, to storing this data. So you can apply encryption at rest quite easily. The classical encryption that your cloud providers offer with the checkbox of setup, encrypt my REST SQL database. And the last question I think that we have here is there a list of personal identifiers that one can rely on to make sure pseudonymization is implemented properly? Well, that's a good question. And there is a bit of a distinction here between Europe and US in terms of this approach. For example, in US, according to HIPAA, there is a list of identifiers that if you remove, your data will be considered almost anonymous, basically, free from subject to HIPAA compliance. This is called de-identification. While in Europe, we don't have such a list of identifiers that are defined by law. Our law in Europe and general approach of the GDPR is to manage risks. So you need to analyze your risk to see what data is, and then it's up to you, your judgment, to identify all the identifiers that lead explicitly to the data. It's a topic that is still under clarification, actually, because pseudonymization and anonymization sometimes are confused. And recently there has been an interesting case. I encourage you to follow our social media and our LinkedIn profile. We released a nice video there of our colleague Pedro interviewing our lawyer Nicola, who analyzed the judgment that said that pseudonymous data plus some manipulation can lead to anonymization somehow. This is really interesting topic. But so basically, short answer, there is no list and there is no one single recipe to do this correctly. You need really to evaluate your risks. And I think we are done. I guess we answered all the questions that we received through our forms. If you have any questions, if you maybe missed this recording for some reasons, don't hesitate to reach out to us via our website or via my email, jovan@chino.io. Sorry for that. You can reach anytime. Happy to answer, clarify all those questions, and looking forward to see you in one of the next sessions where we're going to talk about something else, another topic that is that we identify as the most relevant in the digital health space. Thanks for watching, and don't forget to subscribe. Looking forward to see you next time.